हो गया हो गया। See, if we talk about the preamble, then in preamble we see the preamble is known as keystone, or we can say that from preamble we can understand the nature of Indian Constitution. So if we look at the preamble, then there is a concept of justice. There is a concept of justice is given in the preamble. As we read that we, the people of India, do solemnly resolve to constitute India into a sovereign, secular, socialist, democratic republic and place to provide justice. What kind of justice? So, socio-economic and political. And then there is that we will provide equality, fraternity, liberty. So, in order to achieve the desire that Indian Constitution has provided, we need a strong judiciary. We need a strong judiciary. Why we need a strong judiciary? Because if we want to eliminate all the wrongdoings of the society that was prevailed in it since time immemorial, or ancient time, or till the civilization has been exist, and all the injustice provided by the British government to the common people of India, there should be the justice for the people in the sake of social, economic and political justice. And to achieve this, or in order to ensure that in future also the government will not do injustice with their citizen, and the government will not do injustice to the citizen, and the assurance or insurance of rule of law and assurance of supremacy of constitution, a strong judiciary is important. So, strong judiciary is important. Now, if we look at the concept of justice, and if we talk about social justice, then how we can interpret the term social justice? What we can mean or what we can understand through the term social justice? Mishaps happening on societal level. For example, what kind of mishappenings? Casteism, untouchability, then regionalism, communalism, gender biasness, this type of social mishappenings. And there are certain example, for example, division of society on the basis of their color, this type of sorts things. So, in order to eliminate these things, or in order to ensure that this type of social malpractices will not be present in the society, there should be a prevalent organization which ensures social justice. Now, what is economic justice? How we can interpret the term economic justice? How we can interpret the economic justice? Simply, if we discuss the provisions of DPSP, equal pay for equal work, proper distribution of resources, inequality in terms of income, we can say that. So in order to prevent any individual or any section within the society or within a geographical area from this thing, there should be मालूम in order to ensure that no one can affected by these things, no one can feel economic inferiority, no one can do begar, no one can feel that the for same work they have been paid less as compared to other individual. No one can feel that on the ownership of the society they have less access to the society. So in order to ensure economic equality, economic inequality, we can say that, or we can assume that there should be an organization which ensures economic justice in the society or in a geographical area. Now the comes political justice. What is political justice? How we can interpret this justice? Have right to vote, access to have vote or to choose the government by any other method, equality in the sense of all political rights, for example formation of any organization that involve in politics, supporting any organization in order to supporting any particular ideology of any political organization, access to participate in the election process or whatever the process to form the government, access to cast their vote. No one can be discriminated on any ground in order to participate in the government process or in the government also. So this is a political justice. Now here it can be said that the individual from particular income will have the rights of vote, but some class of society which does not have a standard level of income will not have the access to vote. So this will be the political injustice. For example, in many countries it has been said that the voting rights are given to men also. Then there is a gender a political injustice on the basis of gender. There is there are certain process of election, as for example the first past the post system, proportional representation through single transferable vote system, in which some section of the society does not have a proper say in the election process because of numbers. They are less in numbers, so they cannot able to send their own representative to the house, to the legislature. So this all are the example of political inequality. And in order to ensure political justice, in order to ensure that all the section of the society, all the individual in a society will have same kind of political rights, will have same kind of political things, there should be an organization which look after these things. So this is why the judiciary is important, and that we are going to discuss from today. Understand the basics need of judiciary, why it is important. Now, as far as judiciary in India is concerned, so our constitution is based on the separation of power. Our constitution is based upon the separation of power. Now, what is separation of power? So, the power and functions among the legislative, executive and judiciary will have different powers and functions. So, this is the core principle of Indian Constitution. As far as legislative and executive is concerned, so as per the provision of Constitution of India, we have a legislature at union level, that is center level, that is parliament. We have a legislature at union level, that is parliament, and we also have a legislature at state level, which is known as assembly, state legislative assembly, or in some state is state legislative council. Similarly, we have union government, for example, prime minister, and we also have state government headed by chief minister, practically headed by chief minister. But there is no such division among the judiciary. The judiciary is not divided on the union or on the state level. It means that the Constitution of India has provided an integrated judiciary. What does integrated judiciary mean? Integrated judiciary means that the judicial system will be common for the union, state and also for the local government. It will not be similar as the government of union have certain powers, government of state have certain powers, local government have certain powers. Their powers and functions are divided. For example, in normal circumstances, the union government cannot interfere on those subjects which are mentioned in the state list. And the state list does not have any power or any say on the subjects mentioned in the union list or residuary list in normal circumstances. Similar goes to legislature. In brief, we will understand this separation of power while we will discuss the union-state relation. But for example, there are certain division among union and state. But as far as judiciary is concerned, judiciary is totally integrated. There is only one judiciary for the both, for the union, for the state. Because why this thing is provided, or why the integrated judiciary, provision of integrated judiciary is mentioned in the Indian Constitution? There are many logics. One logic is that Indian Constitution provides single citizenship. Indian Constitution provides only single citizenship. We are the citizen of India. We are not the citizen of India as well as citizen of Jharkhand. If we compare with the USA, which is also a democratic country or federal country, so there is you are a citizen of USA and also the concerned state, but there is no such concept here. Since the citizen is one, the constitution is one, then the body which will ensure the prevalence of constitution should be the one. Why? If the body which is considered as an interpreter, guardian of the Constitution of India is divided or separated among the union and state, then it will lead to more conflicts than resolution. So these are the few logics that we can provide if someone asks that why The integrated judicial system has been provided by the Constitution of India. These are the logics, and there are n numbers of logics that we can interpret after understanding the whole syllabus. Is that clear? Okay. Now, among the separation of power between union and states, there is also the independence of legislature, executive, and so the judiciary. What type of independence? The functions of a legislature will be performed by the legislation house only. Executive cannot interfere on it. And same goes for executive. The functions of executive will be performed by the executive only. It will not be the legislature or judiciary will not interfere in these things. This is the judiciary. And so the judiciary, the functions or the responsibility given to the judiciary by the Constitution of India, no other two organs will interfere in the judiciary. But nowadays, as far as polity is concerned or Indian Constitution is concerned, there are 2-3 things which will remain in debate till I think 2029. One thing is the relation between judiciary and executive. Recently, if you all have followed the current affairs or have listened, that the Vice President of India has commented that the judiciary is acting like extra legislature body. The judiciary has given, Supreme Court has given a decision in which they have fixed the timeline for the approval of bill by the governor or the head of the executive. And in return, the president has written a letter to the Supreme Court. There are certain MPs who has given some sort of statement which are not considered as judicially valid statements. The judiciary has warned all those MPs, because MPs have privilege to say anything within the house of the parliament, not outside the house of the parliament. So there is a tussle between judiciary, executive and legislature, and this topic will remain till 2029. There are certain statements given by the CJI, Chief Justice of India, that once if an individual retired from the post of Chief Justice of India, then he should not be accept any other post provided by the government or any other beneficiary post, in order to maintain independency of judiciary. There is one judge of High Court who has been asked to resign, but he refused to resign. So there is a debate going on that whether the impeachment process for the particular judge will be introduced in the parliament or not. Since 1950, when the Constitution of India was implemented, only once the impeachment to remove a judge from the court had been introduced in the parliament, but not able to pass, because before completing the process, the house gets adjourned. So the judiciary is in news for this type of things. So we can say that the judiciary in India is independent, integrated, and the main functions, or we can say the main responsibility of judiciary is to maintain the supremacy of Constitution. It is the judiciary who has defined that It is the judiciary who has defined that what is the basic structure of the constitution. It is the judiciary which has interpreted the constitution. It is the judiciary which has elaborated the concept of right to life and personal liberty. It is the judiciary which has says that the right to have access to information is also a part of fundamental rights. It is the judiciary which have says that right to inclusive justice is a part of fundamental rights. And other major responsibility of judiciary in India is to establish rule of law. To establish rule of. So this is the introduction of the judiciary. So write down few things. Write down, among the noble aims and objectives of the Constitution the founding fathers accorded the highest place to justice. The preamble speaks of we, the people of India, resolving to secure justice, social, economic, and political. To all citizens. The presence of justice above than other principles of liberty, equality, and fraternity. Makes justice most important and crucial as per founding fathers of Indian Constitution. Next point. Again, the preamble clearly enjoys precedence to social and economic justice over political justice. People turn to the judiciary in the quest of justice. Next point. The Constitution of India lays down the structure and defines, delimits and demarcates the role and functions of every organ of the state including the judiciary and establishes norms for their interrelationships, checks and balances, independence of judiciary, is essential to the rule of law and constitutional norms. Now, if we talk about the structure of the judiciary, then we have a Supreme Court at the top of the hierarchy. At the top of the hierarchy. And the jurisdiction of Supreme Court is over the country or over the all geographical areas of the, and beyond or below the Supreme Court there is a hierarchy of subordinate court, and at the state level there is one High Court. One is Supreme Court, then we have numbers of High Courts for different states, and in some cases on 2 or 3 states there is only one High Court. And the jurisdiction of High Court is limited to the concerned state. And beyond the High Court, there are subordinate court. And in order to understand this, we can say the district court. So every district has district court that are of two nature, one for criminal cases and one for civil cases, that we will discuss in detail. And the subordinate courts works under the direction of High Court. High Court have power over the subordinate courts, and Supreme Court has power over the High Courts. For example, the Supreme Court has power to alter the decision of High Court, and so the High Court has power to alter the decision of subordinate. But within the courts also, within the High Courts there is a single bench, two bench, full bench things that we need not to know for the competitive exam, that are important for those who are preparing for judicial civil services. So this is the structure of judiciary in India, which is integrated. So write down provisions in regard to the judiciary in India are contained in Part 5. The Union. Part 5 is all about the Union under the Chapter 4, titled The Union Judiciary. And part 6, that is the states under chapter 6 titled subordinate courts respectively. Write down, for entire Republic of India, there is one unified judicial system. One hierarchy of courts with the Supreme Court as the highest court and also as the arbiter in matters of relation between the union and the states and among the states. So this is the general introduction about the judicial system in India. So how we will discuss the judiciary? First we will discuss the Supreme Court, then High Court, and then subordinate court. And then there are certain terms related to judiciary, for example, public interest litigation, judicial activism, judicial overreach, this type of things we will discuss. So first we will start with Supreme Court. So as for constitutional provision, Supreme Court is at the top of the judicial hierarchy. Top of judicial hierarchy. And it exercise or influence, and it has overriding powers over the high courts. One thing we can also talks about the judicial system of India that I have not mentioned here, that the judiciary in India is organically linked. Now what do you mean by organically linked? What is organic? Time memorial or but here we will say it organically means on the basis of organization they are connected to each other. For example, the judges of High Court can become the judges of Supreme Court. This is the one example. Now, as far as Supreme Court is concerned, what are its major functions? What are the major functions of Supreme Court? So first and foremost functions that we can say about the Supreme Court is that He is the custodian of Constitution. So write down, Supreme Court acts as a custodian of Indian Constitution and how we can say that the Supreme Court is custodian of Constitution? How we can say that? Is there any logic or is there any example? Yes, we can say that the Supreme Court is custodian of Constitution because any activity or any work performed by either legislative or executive is not as per consonance of the Constitution, then the Supreme Court has power to nullify the decision. For example, in around 2014, there was a concept of National Judicial Appointment Commission. Similar to the UPSC, for all India services, there is a body called UPSC. For state PCS, we have JPSC. So the government, the India government in 2014 has drafted a bill in which they mention that they will form a National Judicial Appointment Committee. This committee will be responsible for the appointment of judges, Supreme Court judges, High Court judges, Chief Justice of India, Chief Justice of High Courts. And they have mentioned that within the Judicial Appointment Committee, there will be members from executive also. They have amended the Constitution, passed the proposal, but the Supreme Court of India has nullified this amendment to the Constitution. Why? Because they have given a logic, they have given a reason. What reason? They have said that in more than of 40% of cases filed by that are in the courts in which the government is either a part or the case is against the government. So if any individual who is responsible for more than 35-40% cases that are under trial or pending in the judiciary, if he becomes the member of such committees who will appoint the judges, who will decide the cases upon which the same body is a party, then there is a question mark of credibility. There is a question mark of independence. And the Constitution of India has provided for an independent judiciary. And this will breach the independence of judiciary. That's why they have nullified this. Understood or not? Okay. So write down, Supreme Court acts as custodian of Indian Constitution by turning down every action of the organ of the state going against the values of Constitution and thus Supreme Court ensures that supremacy of Constitution is maintained. Now there is a concept, custodian of Constitution, that I have explained. Hope you all understood it. There is another constitution, that supremacy of Constitution. How judiciary ensures the supremacy of constitution? Constitution of India is a living document. How we can say that? There are more than 100 amendment of the constitution. So constitution is living document, which derives that there is a possibility to bring some sort of changes within the constitution, and there are certain changes are brought up in the constitution. For example, 86th Amendment Act. What is 86th Amendment Act? Article 21A, right to free and compulsory education for the children in the age group of 6 and 14 years of age as prescribed by the state. These were not present in the original constitution. This was added by the 86th constitution. So there is a possibility of changes in the constitution. And there are certain other example, we can say that 73rd and 74th Amendment, which introduced local self-government for the rural and urban areas. If there is a possibility of changes in the constitution, then who is responsible to brought changes in the constitution? Parliament. Parliament is authorized to brought changes in the constitution. The Parliament can amend the constitution. It was authorized by the constitution itself under Article 368. Now, suppose that if any organ which have power to brought changes within the Parliament, and if there is no other watchdog or no other organization or body which look after the changes brought by the concerned authority, then there is a probability or there is a chances that the changes bring and brought up by the concerned authority, and slowly and gradually they make itself more powerful than other organs. There is a probability, there is a chances, there is a scope. Suppose that if you are allowed to use the exchequer of government of Jharkhand, and there is no anyone present to look after you, then there is a probability or there is a maximum chances that you will utilize the exchequer for your personal gains, or by using the exchequer of state you will make yourself more powerful than any other individual of the state. So there should be a body to look after the Parliament, who is responsible or who is empowered to brought changes within the Parliament, and so the presence of judiciary to look after the changes brought up by the Parliament. There is a judiciary, and judiciary has a power, and or we can say that judiciary is the custodian of constitution. So the judiciary will see or check all the changes brought up by the Parliament is as per consonant or as per sound as the provision of constitution or not. Whether the changes brought up by the Parliament is going against the supremacy of constitution or not. So this is what the concept of supremacy of constitution and how the supremacy of constitution is ensured by the judiciary. And in order to this, they use certain tools, for example, judicial review that are provided through Article 13, 32, 226 and many other articles. There is a concept of judicial activism. There is a concept of judicial overreach. That we will discuss all these things. The judiciary maintain supremacy of constitution through the tool of judicial review, through the tool of judicial activism, through the tool of using judicial overreach. And there are certain many provisions, especially petition interpretation of these things. Hope you have understood these two things and how these two things are maintained by the Supreme Court. So this is the first important function of the Supreme Court. Now next is Supreme Court is the highest court of appeal. Write down, Supreme Court is the highest court of appeal. Now what do you mean by the highest court of appeal? So it is at the top. You cannot go beyond Supreme Court. And you can approach Supreme Court against any decision given by any subordinate judicial body. For example, if someone is not satisfied with the verdict given by High Court, then he can approach the Supreme Court. So it is the Supreme Court which is the highest court of appeal. Next, Supreme Court acts as primary protector of fundamental rights of individuals guaranteed by them to the Constitution. Primary protector of the fundamental. How we can say that? Simply Article 32. What is Article 32? Any individual can approach directly to the Supreme Court if fundamental rights are violated. So Supreme Court is the primary protector of fundamental rights of a individual. It serves or it behaves like a primary protector by two ways. One, if someone approaches to the Supreme Court, if his or her rights are violated, and through the power of judicial review, it always checks that whether state not turn into an arbitrary state. It always checks or decides the limits upon the state, upon the four boundary wall of state. So it serves as a primary protector of fundamental rights by two ways. Fourth function is that Supreme Court has consultative role. Where it acts as advisor of President on any issue of fact which is of public importance. So Supreme Court also had consultative role. To whom it serves as a consult? President. It serves as a consult for the President of India. On what matters? On the matters on which Supreme Court feels that I should advise the President, or on certain matters on which President thought that I should seek the advice of Supreme Court. So this is a two-way relation. One way that Supreme Court can provide advice to the President, and President can also seek advice from the Supreme Court on such matters in which he thought important. There are certain articles, article 143 is also there. Next functions. Write down Supreme Court is the final write down Supreme Court has final interpretation of Constitution. Interpretation of Constitution. Supreme Court is the final interpreter of the Constitution. If something is not clearly mentioned in the Constitution, or we can say that it is the Supreme Court who will read in between two lines of the Constitution. It is the Supreme Court who will interpret that what is right to life mean. Whether right to life mean providing basic essentials to the human beings. Whether the right to life also include the right to have clean environment. Whether right to life have also include to right to have access to the internet. Whether right to life will also include that right to have access of peaceful sleep or not. So it is the judiciary who will interpret the Constitution, and he is the final interpreter of the Constitution. It is the Supreme Court who will decide whether the changes brought up in the Constitution by the Parliament is in the same sense of the Constitution or not. For example, there are certain debates around the changes brought up within the preamble. the inclusion of word secularism, socialism and integrity through 42nd Amendment Act 1976 or 76. So it is the Supreme Court who has finally said that though the word socialism and secularism was added later on, but the nature and the features of the constitution is tilted towards to provide secularism or socialism, and we can refer that the presence of socialism through the presence of Article 14, Article 15, Article 16, Article 25, 26, 28, 29, 30. So it acts as a final interpreter of the constitution. Next one, next functions. Supreme Court is sole arbitrator between center state and among states over dispute of power and thus maintain a spirit of federation in India. Suppose that since the power and responsibility is distributed among center and state, so there is a chances of conflict between center and state. For example, conflict with respect to division of revenue. For example, conflict in between among the states also. There is also a chance of conflict among the states also. For example, some sort of mineral, some sort of mines, some sort of land, some sort of electric division, some sort of various things. So there should be a body which should act as an arbitrator. It should act as an arbitrator. That is, which should solve these problems. And the problem solved by the Supreme Court. And Supreme Court act as a sole arbitrator. That is, no other body who can resolve the disputes between center and state. If two states caught in a conflict, then then the solution is Supreme Court. The High Court cannot resolve the solution between two states. Why? Because the High Court of one state will have jurisdiction within the state, and the High Court of other state will have jurisdiction within their state. And it cannot take any cases which goes beyond the power. And if it takes such cases, then there is a concept of writ. And in order to performing the function of arbitrator, the Supreme Court maintain the spirit of federalism. So these are the important functions of the Supreme Court that we have seen in a glance. But we will discuss in detail also. Now next is judges of Supreme Court. Judges of Supreme Court. So, who is authorized to decide the number of judges in Supreme Court? So, it is the Parliament. Who will decide the numbers of judges of the Supreme Court? And from time to time it has increased the numbers. And what is the strength right now at present? Huh? 5 what? Only 5 Supreme Court judges. So it is the Parliament who decides the number of judges. I think right now is 34. Go and check it. Now next is who can become judge of Supreme Court. What are the qualifications that needed to become judge of Supreme Court? So first requirement is that he should be citizen of India. First and foremost requirement. Those who is citizen of India can become a judge. Next, has been working or has been for at least 5 years as a judge of High Court. Five years has been judge of High Court, then he is also eligible to become a judge of Supreme Court. And it is not necessarily to have a High Court judge for 5 years in one High Court. It can be in succession also. So write down a judge of High Court or two or more such court in succession. Third is has been for at least 10 years practicing in High Court or in a 2 or more such court in succession. an individual, if he is practicing the law or he is serving as an advocate at High Court continuously for 10 or more years, then he is also eligible to become Judge of Supreme Court. So any individual, if he is citizen of India or practicing as an advocate for 10 or more years or at least 10 years at High Court level in 2 or more successive state, then he is eligible to become a lawyer. And then if he is Judge of High Court for 5 years or of such other courts in succession, then he is also eligible to become a Supreme Court. And there is one another ground. Write down: a distinguished jurist in eye of President. If any individual is a distinguished jurist in the eye of President, that is, if President thinks of any individual possesses certain high qualities that he should be appointed as a Judge of Supreme Court, then President can appoint him as a Judge of Supreme Court. And what is the difference? What is the definition of distinguished jurist? So we don't know. What does distinguished jurist mean? Because there is no particular definition given in the Constitution. So it is we can say, on the consciousness of the President. We can interpret this qualification as such like that if President thinks of someone who has a certain distinct characteristics, then he can make him the Judge of Supreme. So these are the general qualifications that needed to become a Judge of Supreme Court. Now, next thing is that appointment. Appointment of judges. So, in order to appointment, there are two types of judges are appointed in Supreme Court. What two types? One will be appointed as Chief Justice of India. There is one CJI, Chief Justice of India. So, the criteria to appoint Chief Justice of India, one, and second, as a Supreme Court judge. As a Supreme Court judge. Now, what are the constitutional provision? So, constitutional provision is given in Article 124. Just after the ordinance 123. So, write down Article 124 vests the power of appointment of Chief Justice of India and the judges of Supreme Court in the President. So, as per Article 124, who is authorized to make such appointments? So, President. President is authorized to appoint Chief Justice of India and other judges of Supreme Court. write down, the president shall by warrant make the appointment after consultation with such judges of Supreme Court and the High Courts of the state as he may deem necessary. Since we know that, write down, look here, that since we know that the president cannot do anything on his own. So it has been said in Article 124 that the Chief Justice of India and other judges of Supreme Court will be appointed by the president by warrant under his hand. But there is a condition that he may consult. He may consult. To whom? To such judges of Supreme Court and High Court as he may deem necessary. As he may deem necessary. Similarly, there is a provision related to Council of Ministers, that there shall be a Council of Ministers headed by Prime Minister to aid and advise the President. Similarly, the Constitution under Article 124 says that the Chief Justice of India and the judges of Supreme Court will be appointed by the President. This is the first statement. And how they will be appointed? Under warrant of his hand. Under the warrant, that is by the office. This is the first condition. How? Under his warrant. But there is a condition. What is the condition? In order to make appointments, the President may consult such judges of Supreme Court or High Court as he deem necessary. So this is what the Constitution talks about. Now there is a dilemma. There is no clarity. We cannot understand clearly what this statement means. Why? Because of the term, the word may used. May means either or. He may be consulted or he may not be consulted. So this is the provision of Constitution. Now, see it. President, the executive head of state. He is authorized to make appointment on all constitutional bodies. This is the one scenario. Judiciary, independent body of his principle of separation of power. Judiciary will have separate powers and functions. President is responsible to make appointments for the Supreme Court. All the executive functions of the government are performed on the name of President. But in practical, he did not He does not take any direct decision. All decisions are taken up by the Prime Minister and Council of Ministers. This is the practical things. Although the President is the executive head of the state, but for the namesake, practically all the power vested upon the elected government, directly elected government. So there is an ambiguity that how the President, who cannot perform his own work as the head of the executive of the state directly, then how he can appoint a judge without taking advice from the judge. So this is the ambiguity. And due to this statement, there are certain cases that we will see, all the cases, basically 4 cases, in which this dilemma or this confusion has been elaborated by the Supreme Court. Why by the Supreme Court? Because it is the Supreme Court who is the final interpreter of the Constitution. President cannot say that it means that I will not consult anyone, I will do anything. It is the judiciary who will decide what this statement means. And through these cases and the judgment of these cases, the concept of collegium system was arrived in India and follow till date. Write down the provision speaks of after consultation and not in consultation. There is another problem related to this article. What is the problem? The President appoints the Supreme Judge, that is CJI, the apex or the highest position in a judicial system, and also the judges, and there is a difference between these two. Now if the provision is given that he will consult such judges, so practically if the subordinates, if the appointee who is responsible for appointment consult the subordinates in order to appoint their boss, President consult judges to appoint CJI. So there can be a problem. There is no problem in that appointment of judges and consulting the judges. Not in consultation. In the case of appointment of a judge, other than CJI, the CJI shall always be consulted. Next point. On a plain reading of the provision, the appointment vests in the President. If simply we read the statement, it means that the appointment will be made by the President. Now what are the repercussions of this statement? President means the executive. President means the executive. The president acts on the advice of council of ministers. So this is the problem. What is the problem? President means executive, and executive means council of minister. So same thing that we have discussed at the starting of the class, NGAC. So therefore, through 4 cases, we derived the collegium system through which judges are appointed in the Supreme Court and also in the High Court. And the cases we will discuss in next class. If you have or anyone have any problem, then you may ask, or we will start from here from next class.